Welcome to the Florida Bar Podcast, where we highlight the latest trends in law office and legal practice management to help you run your firm. Brought to you by the Florida Bar's Practice Resource Center. You're listening to Legal Talk Network.
Hello, and welcome to the Florida Bar Podcast, recorded from the 2019 Florida Bar Annual Convention in Boca Raton, Florida. This is Geoff Probst, and I'm the host for today's show. Joining me now, I have Peggy Hoyt and Alex Douglas. They were co-presenters this morning on the Elder Law and Estate Planning Case Update, and they're going to get to tell us a little bit about what they talked about this morning now. So before we get started, I'd like to give you both the opportunity to tell us a little bit more about yourselves. So why don't we start with you, Peggy? Where do you work and what do you do?
So I work in Oviedo, Florida for the law offices of Hoyt and Bryan, and I am the outgoing chair of the animal law section and a member of the executive council of the solo small firm section.
All right. Well, if we have time, I know we want to talk about the animal law section work at some point, so we'll see if we can get to that. All right. And Alex, how about you?
I am a partner with Shuffield, Lowman in Orlando, Florida, and I practice in the area of probate, trust, and guardianship litigation.
All right. Well, we're not going to ask you to repeat the entire presentation you gave this morning, but let's jump right in. I know that you had some practice tips based on some of the case law updates. Let's start with qualified beneficiaries.
So there were a number of cases this last year on the definition of qualified beneficiaries, and both Alex and I think that this is something that's going to continue to be at issue in the future. You need to look at the statute. You need to look to all the beneficiaries that are named in a will or a trust, and then make a determination if they are quote-unquote qualified beneficiaries. And Alex has a really good practice tip in this area.
I do, and we're purposely not mentioning cases during this presentation so that hopefully you guys can go back and view the recording of the presentation this morning on the probate and elder law update. But one of the key points that we were making with regard to this issue of qualified beneficiaries is that from a litigation standpoint, it is very important when you bring an action, a trust litigation action, that you name all the qualified beneficiaries. Because if you do not, whatever judgment you're getting from the court, whether it's modifying the trust or clearing up an ambiguity, if you don't have all the qualified beneficiaries named, then those persons who have been omitted from the lawsuit will not be bound by the judgment. And therefore, it's important that you go through the analysis like what Peggy was saying. One of the things that we learned about today is that if you have a remainder beneficiary that is a charity, there is a special statute that addresses what a charitable qualified beneficiary is and special rules that apply to that. Additionally, if you are in doubt as to whether a person or party is a qualified beneficiary, don't leave them out. Or also don't name them as a qualified beneficiary if you're unsure. Rather, include them as a party and include a declaratory judgment count to ask the court to declare whether or not that person is a qualified beneficiary and cite that there is an ambiguity and you're unsure. That's a far better practice to do that and get a judgment declaring that they're not a qualified beneficiary than taking the risk that you omitted someone that is important to have bound by your judgment.
I think that's an excellent practice tip, Alex. And the other reason that qualified beneficiaries are so important is that they are entitled to the annual trust accountings each year. And so if you're not giving your trust accountings to the correct people, again, you won't be bound by those accountings. The statutory 6-month time period won't run on the notice to the proper beneficiaries, and you could end up with a breach of fiduciary duty count later on.
Excellent point, Peggy. The running of the statute of limitations is really so important, and one of the worst things that you can do is fail to give that yearly annual report and accounting to the beneficiaries, because if you disclose what you did and they don't take action within either the 6-month limitation notice if you provided one, or the 4-year regular statute for a breach of fiduciary duty if you didn't give the shorter limitation notice, then they're on notice as to what happened, and it's up to them to do something about it.
That's great. Those are good tips. Now, we talked before we got on the mics a little bit about some other practice tips with respect to homestead issues, I think.
Sure. Peggy and I spoke about a couple of cases dealing with the issue of homestead rights, particularly with regard to the election that a spouse can make to either take a life estate of the homestead when her spouse or his spouse has passed away, or a 50% interest in the property. And one of the things we learned is that is a statutory limitation that has to be met. If you miss that statutory time by which to make that election, then excusable neglect does not apply.
And if you do need an extension of time, it's important to note that extension has to be requested timely, so before that 6-month time period elapses. The other thing that's important to note here on just a practice pointer basis is that this might become a mathematical equation for some folks, depending on the age of the surviving spouse and the value of their life estate versus the value of their 50% interest. But both Alex and I have been involved in cases where we have surviving spouses that are not related to the lineal heirs who might be the remainder beneficiaries, and trying to avoid some of the remainderment type litigation or just problems that come up with regard to the maintenance of the property.
Exactly, and I've been involved in some of those cases, and I don't think it's purely one of finances, though financial effect will obviously in most cases drive the decision, but the non-tangible issues of how well do you get along with the remainder beneficiaries, because if there is animosity between the life tenant and the remainder beneficiaries, there could be a lot of issues and problems with regard to whether the life tenant is properly maintaining the house, what damages to the house the life tenant is responsible for versus what the remainder beneficiaries are responsible for. There's a lot of complications where if you don't have a good working relationship between the life tenant and the remainder beneficiary, there can be litigation. So if you're advising the spouse in a situation like that, if the money part is maybe equal, or even if it's a little less favorable, if you have that situation where you potentially could have litigation down the road, it's not a bad idea to just take the 50% and be done with it.
Great idea, Alex. The other issue that came up on homestead was the definition of voluntarily leaving your home and whether or not you lost your homestead protection where there was an involuntary leaving of the home. So I think that's an interesting one. And then the other one was whether or not a spouse had to, that was the same case, on the involuntary leaving, whether a spouse had to join in the conveyance of that homestead property.
Right, exactly. And so what we learned from one of the cases we had today was that if you involuntarily leave your homestead, that does not relinquish your constitutional rights in your homestead. You have to voluntarily and willingly relinquish your constitutional rights. And of course, we have situations all the time where a spouse, and in this particular case, sold the property to a third party without the wife's signature. And then also, as Peggy mentioned at the presentation today, we had a case together where the husband took out a second mortgage without the wife's signature. So these issues do come up, and it's important to understand the uniqueness of the Florida constitutional protections and homestead.
So the homestead issue can also come up in an elder law or asset protection, Medicaid planning context, where a person's in a nursing home, no longer living in their home. Was that a voluntary or involuntary abandonment of the property? And usually there's an intent to return home, so we can maintain the homestead status of the property.
Peggy, that's an excellent point.
That's great. It sounds like you got a few points in there that if you're dealing with litigation, at the very least, if you can't avoid it, you can do a few things to be prepared for it. So, all right. How about guardianship? That was one of the other topics you hit this morning, wasn't it?
So there was an important case this last year with regard to guardianship, and I regularly say to my clients that guardianship is probably the worst kind of a lawsuit because it's one that your family files against you. You get to pay for it, and ultimately you lose. So in this particular case, there was a man, we'll call him the alleged incompetent person, who was deemed to be incompetent by a three-party panel, but ultimately the court found that the panel did not strictly follow the regulations of the statute requiring both a physical and mental examination. So ultimately that case had to go back down, have a new panel appointed, and I think this was the right result, and I think Alex will agree with me because it's for the protection of the ward.
Yeah, so though there was a stinging dissent in that case arguing that from a practical standpoint there's only so much resources and it doesn't make a lot of sense to strictly interpret the statute requiring every examining member, including like a social worker, to do a physical exam, and cited to the body of case law and practice procedure whereby an expert is allowed to rely upon the reports of other experts if that is something they do in their typical practice. So here, the doctor did look at medical records where there was a thorough physical examination, and the dissent was pointing out that that was perfectly fine. This is a very difficult issue because, as Peggy mentioned, a guardianship is a very terrible situation for a family to face. It's really a situation that a family should never get to if they do their proper estate planning. And one of the things I tell my friends and neighbors is the most important document, I think, even beyond a will or a trust, is a power of attorney. Because if you do a power of attorney, giving a trusted individual the ability to handle all your financial affairs and any other powers you want to give them, then if you do become incapacitated in Florida, then should be no need for a power of attorney. Same thing with a living will or a health care surrogate designation. You want to designate someone to make all your medical decisions. So if you become incapacitated and you can't, then they can do that for you. That avoids, in most circumstances, a guardianship. Now, where we have a bad person, a bad child that abuses the power of attorney, then you cannot avoid a guardianship because there the lesser restrictive alternative of the power of attorney is not going to be sufficient. And unfortunately, we're seeing more and more of these exploitation cases in Florida where you're ending up in guardianship court because of a bad family member.
Point well taken. So do your estate planning early and often.
Absolutely.
I know that we're running a little bit short on time, but I think we have time for at least one more topic. So I think, and maybe two if we're lucky.
I want to talk about animal law.
I know you do. All right. Let's see if we can't get them both in. Irrevocable trusts. Let's hit that first, and then animal law next.
One of the cases that we talked about earlier today involved a grantor that did an irrevocable trust and then basically wanted to get out of it. Well, an irrevocable trust is just that. It's one where a person sets up money to be held in trust for another person and cannot be changed. Very dissimilar to a revocable trust, which most people are familiar with, where the grantor is often the trustee, and the function of the trust really doesn't come into effect and certainly does not become irrevocable until the grantor dies. But where a parent or a person may implement an irrevocable trust, there could be a lot of different reasons for that. It could be as easy as my children keep hounding me to change my estate planning, and I want to avoid that by doing something that's irrevocable that I don't have to worry ever again about changing. If you do that, just remember, you can't change it. Now here in the case that, again, if you go to our presentation, you can get the details and the citations, dealt with the creative argument of getting out of a irrevocable trust by arguing unilateral mistake. The court didn't buy it. The DCA agreed that no, a unilateral mistake is not sufficient to get out of an irrevocable trust. You have to show undue influence, fraud, in order to rescind an irrevocable trust. And the facts of the case just didn't support it.
And I know everybody wants to hear about planning for your pets, so we're just going to talk real quick about when you do your estate planning, if your pets are valued members of your family, which they likely are, you want to make sure that you include your horses, your dogs, your cats, your birds, your tarantulas, your guinea pigs, and your chinchillas as part of your estate plan. And if you need help with that, you can definitely reach out to an estate planning practitioner. If you need a pet trustee, you can look to animalcaretrustusa.org.
Peggy, I'm just curious, with regard to pet trust, what is the typical amount that people leave for their pets?
I try to get people to leave as much as is necessary to provide for the lifetime care of that pet. So it's going to vary based on the pet. So if you have horses, you got to leave a lot more money than if you have an elderly dog, for example. So it's a case-by-case analysis, and it just depends on how you want your pets to be cared for. If I die, I want my pets to stay in their home. So, of course, that's going to cost a lot more than whether I were to give my pet to somebody else and then just provide for its lifetime care.
And what is the most interesting or unusual type of pet you have ever provided a trust for?
I think chinchillas, but I'm working with a gentleman right now that we're planning for North American spotted turtles.
Who would have known?
It's amazing.
You love who you love, Alex.
Absolutely.
All right. Well, it looks like we have reached the end of our program. I want to thank Peggy Hoyt and Alex Douglas for joining us today. If our listeners have any other questions or wish to follow up with you, how can they do that, Peggy?
So I can be contacted at Peggy@HoytBryan, HoytBryan.com.
Right. And Alex?
And I can be contacted at adouglas, ADOUGLAS, at SLLAW.com. Slaw with 2 L's.
And you both mentioned the presentation that you gave this morning. If listeners wanted to try to access that or get it, how could they do that?
Through the Solo Small Firm section of the Florida Bar and the Florida Law Update, and it will be available after the end of this conference.
Wonderful. Well, that's all the time we have for this episode of the Florida Bar Podcast. Thank you to our listeners for tuning in. If you like what you heard, please rate and review us on Apple Podcasts, Google Podcasts, Spotify, or your favorite podcasting app. I'm Geoff Probst. Until next time, thank you for listening.
Thanks for listening to the Florida Bar Podcast, brought to you by the Florida Bar's Practice Resource Center and produced by the broadcast professionals at Legal Talk Network. If you'd like more information about today's show, please visit LegalTalkNetwork.com, subscribe via iTunes, Google Podcasts, Spotify, and RSS. Find the Florida Bar, Legal Fuel, the Florida Bar's Practice Resource Center, and Legal Talk Network on Twitter, Facebook, Instagram, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.